Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. There's been a lot of talk about the differences between military and non-military divorces and how they are handled. I will tell you this, having done a lot of both, there are some differences right off the bat. The crux of how to handle a divorce case and how the court will view it is really pretty much the same, but here are some differences. Number one, the court will typically look at, in a standard non-military divorce, the court's going to look at jurisdiction of have the parties lived in the state of Michigan for at least 180 days prior to filing, and have they lived in the county where they filed for at least 10 days. That's what the court's going to look at. In terms of where the child is, the court always likes to look at jurisdiction in terms of where does the child reside? What's the home state of the child? These are issues that come up in divorce cases. They could come up in custody cases that are outside of the incidence of marriage. So these are things that the court looks to. In a military divorce, though, we've got a completely different way of looking at the jurisdiction. The court is going to look at, for jurisdictional purposes, what's the person's declared state of residency. In other words, when you go into the military, you got to fill out a bunch of forms. One of the forms you got to fill out is you got to make a declaration of where you live. What's your declared state of residency? Is it Michigan? If it's Michigan, Michigan will allow you to come to the court and ask for a divorce or ask for relief of some sort, even though you are stationed in Germany. And you could say, he's been there for years. How can Michigan make a ruling on him? The answer is, for our service people, we give certain allowances. One of them is, if you declare a certain place to be your state of residency, the court accepts that, even though temporarily you may be assigned abroad. So that's one thing that changes in a military divorce. The court's looking at the jurisdiction. The court looks at it a little bit differently. Now, there are other things that come up in a military divorce that may not come up in a non-military situation. For example, there may be a military thrift savings plan that has to be dealt with. Certain monies and credits that people get as a result of being in the military and how those get divided in a divorce. Another thing is there might be certain allotments that come up in a military situation. Like a person may be in, let's say, out of the country. Let's say the person's in Italy and they're stationed there, or they're in England or whatever, and the military gives them a housing allowance, a certain allotment toward their housing. The question comes up, well, wait a minute, if they're getting $3,000 toward the allotment, maybe they're not getting the money, but they're getting a house. The military's paying their rent directly to landlord, let's say. Is that used in calculating income? Is that used in calculating support? Be it child support or alimony, spousal support? Do we use the number? In a normal situation like that, we're going to look at the income. If in a non-military situation, this kind of professional, she's that kind of professional, he's working in this factory, she's working in that factory, we look at the income. We're not calculating because we know from the income they're paying for their house payments. They're paying their rent. This is a different thing. So there's a slightly different calculation in that regard. We're still going to divide up marital assets. We're still going to divide up marital debts. If you have any questions about your military divorce, reach out and we'll be glad to help you out.